Testing 1 2, testing 1 2. Shalom, people. Coming back at you with part 3 of the Know Your Rights. Check it out. I ain't gonna waste too much time. I'm gonna jump right into it. So let's get to it. Be right with you. Right with you. Hey, shalom, people. We're gonna get right to it. That rock while it's going. Clearly, I don't know what the hell I'm doing yet, right? But don't worry about it. We'll get to it. All right, let's go. You know what? Let me turn that bullshit off. I mean, it's not bullshit. I like it. Turn it off.
If a man really hated ads,
Let's go.
Right? Let's go on. No repeal of an enactment is necessary. Since an unconstitutional law is void, the general principles follows that it imposes no duties, confers no rights, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. A contract, did everybody pick up on that keyword, contract? A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, the Constitution, it is superseded thereby. Since an unconstitutional statute cannot repeal or in any way affect an existing one, if a repealing statute is unconstitutional, the statute which it attempts to repeal remains in full force and effect. And where well, what did I say there? Remains in full force and effect. Is the Second Amendment in full force and effect? You better believe it. Okay? Now, what is it they don't understand about infringed? And where a statute which it attempts to repeal remains in full force and effect, and where a clause repealing a prior law is inserted in the act, which act is unconstitutional and void, the provision of the repeal of the prior law will usually fall with it, and will not be permitted to operate as repealing such prior law. In other words, the law stands always.
The law stands always. So basically, what he's saying, people, is that no matter what statute, ordinance, whatever the fuck they got, right, and under the color of law, if it contradicts the law, and this is applied across the board, no matter what it is, civil, criminal, family, the Constitution is the supreme law of the land. So once you learn that, and you learn the difference between the law and their color of law, and realize that they're violating the Constitution, you can tell them to go fuck themselves. Not I mean, respectfully. You can't really tell a judge to go fuck yourself. But you can say this is unconstitutional and I don't recognize it because the Constitution doesn't recognize it. Of course, like he said earlier, and I'm saying again, earlier in the previous videos, you got to have the fortitude. You got to have the stones for this. If you don't exercise your rights, if you don't assert your rights, if you don't exercise your rights, then you don't have them. And if you too chicken shit to stand up for yourself, then whatever happens to you serves you right. So get with the program, people, right? These rights we're talking about.
The general principles stated above apply to the constitutions as well as to the laws of several states insofar as they are repugnant to the Constitution and the laws of the United States. And let's see if 54 will confer. Kuhn versus Berry, but I can tell you Marbury versus Madison is higher than that, but I'd be willing to bet you they cited Marbury in that. Moreover, a constitution of a statute A construction of a statute which brings in conflict with a constitution will nullify it as effectively as if it had, in its expressed terms, been enacted in conflict therewith. So anything passed in conflict with the United States Constitution is clearly unconstitutional. It doesn't take a college professor graduating magna cum laude from Harvard to figure these things out. All you have to do is read. That's why God gave you eyes now. The actual existence. Well, let's go to 257. 257, same book, 16th Am Jurisprudence. The actual existence of a statute prior to determination that it is unconstitutional is an operative fact and may have consequences which cannot justify being ignored. When a statute which has been in effect for some time is declared unconstitutional, questions of rights claimed to have become vested, of status, of prior determinations deemed to have finality and acted upon accordingly, and of public policy in the light of the nature both of the statute and of its previous application, demand examination. All right? It has been said that an all-inclusive statement of the principle of absolute retroactive invalidity cannot be justified. Obviously, it would be ex post facto. An unconstitutional statute is not necessarily a nullity. It may have indeterminate consequences binding upon the people. All right? So you have to pay attention to what's going on. Now, let's get a few more and we're out of here. Section 258. I'm just going to read the important section here. On the other hand, it is clear that Congress cannot, by authorization or ratification, give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. Does that make sense to you? In reality, it would be what? A nullity. Why? Because it's in conflict or repugnancy. It'd be in violation of Marbury versus Madison, all right? Now, are you starting to see the gist of what's going on here? There's just one more, I think, and we're out of here. All right, Section 260 of the same 16th Am Jurisprudence. Now, folks, head down to a law library. The books are usually green or red in color. They're kind of thick. Ask the librarian where Am Jurisprudence 2nd is stored. Go on over there, grab the 16th volume, start at Section 1, and just start paging through to say Section 300. I'm telling you, you won't believe it. We're going to look at Section 260. Although it is manifest that an unconstitutional provision in the statute is not cured because included in the same act with valid provisions, and that there are no degrees of constitutionality. In other words, it's either constitutional or it's unconstitutional.
That's
There's
it.
nothing like, it's kind of like half pregnant. There's no such thing, right? So that an act is either constitutional or it is unconstitutional, okay? So if you got statute here and most of it's constitutional and a part of it's unconstitutional, guess what? It's all unconstitutional. So what we got here is a crime bill. And we got part of it is constitutional and part of it's unconstitutional. Obviously, they had no authority under the Second Amendment to fool around with the right of the people to keep and bear arms. They couldn't demand that the people not possess certain firearms. So this directly applies to this crime bill. Obviously, part of the bill is constitutional and the other part is not constitutional. So what is the end result? The whole bill is unconstitutional. Does everybody see that? Excuse me. Now, I want you to start looking at these things, and I want you to start hammering these guys, and don't let these guys pull this kind of stuff.
Again. Damn, I said again. Again. Understand that he's saying that no matter what they have on the books, if the shit is in conflict with the Constitution, it's null and void. Now, doesn't necessarily mean it's null and void in its well, it does. Let me not even try to confuse you. Anything in conflict with the Constitution is null and void, like keeping and bearing arms. Having guns, that's your individual right. It's protected under the Second Amendment. There is no motherfucker on this earth that can tell you you can't have it unless you're a criminal. That's it. That's it. That you're a criminal, but they can't get you for possession of a firearm, just on GP because it's your right to have it, to keep it, and to bear it. Right? That's your fucking right. They got a lot of people locked up behind, possession of a handgun for unlawful purposes. Fuck you. Well, who determines that it's unlawful? Like, if I'm walking down the street with my weapon, there's nothing the best. I mean, they can stop me, they could arrest me, they can make my life living hell. But at the end of it, if I stand firm on the Constitution, they can't beat it. There's nothing that they could do. They could come up with all that shit. That's why they offer you, put you under duress, threat, duress, coercion to you to get you to cap out. You know, one lawyer told me that somebody I know is you just forced them. Anyway, know that anything that's in conflict with the Constitution is not valid. It doesn't matter. Like all the videos that they show of police running up in people's houses without a warrant, that's illegal. You could sue the shit out of them. You could sue the shit out of them for violating your Fourth Amendment, your Fifth Amendment, First Amendment, Second, whatever they violate. You have like due process. These motherfuckers do not give you due process, especially in family court. Family court, that whole shit is a fraud. They tell you that you don't have any options. Fuck you. I don't even got a contract with you anyway. Let's keep going.
Hook them. Go over there and collar him. Say, hey, Charlie, why don't you step over here for a minute? I want to check out something here. I mean, you would if they had your wallet.
Yeah, I didn't hear none of that, huh?
Does that make sense to you? Now, we're going to get into a unique argument here. For the last half hour, I've been trying to hammer home the power of this book. This book right here. Okay? I'm trying to hammer home the power of this book to teach you that this is the most valuable book in your whole life. If you know what's in this book, I am telling you, you are in full possession of your American citizenship. If you don't know what's in this book, I am telling you, you're going to be a slave, subject to the whim of extrajudicial people who want to tell you what to do, when to do it, and how to do it, and how high to pack it.
Okay. You heard nothing I said earlier because the mic was muted. Understand what he's saying. Again, if you don't know your rights, you don't have them. And without them, you're a fucking slave. Now, we're all slaves in a sense, right? The freedom that we have is to choose 31 flavors in any shoe, right? We can shop anywhere, we can live anywhere within reason because, you know, you ain't just moving into certain towns. They've priced you out of that shit. But that's beside the point. Your rights, they're God-given and they're enumerated. And he's telling you learn them. I'm telling you learn them. I'm saying learn your fucking rights and exercise them, assert them, invoke them, so that these bastards in government, whether they're in law enforcement on a local level, federal level, state level, whatever it is, whatever you're dealing with in the courts, don't let these bastards violate your rights, and they will, right? They'll get you. They'll trip you up. They'll coerce you. They'll threaten you. They'll put you under duress, means they'll stress you out. They'll have you in fear, which is duress. They're coercing you. They're coercion. You can't let these bastards do that. So he's saying, learn that shit and you'll be free. I mean, free to move about the country, free to do what you want to do in this bitch. As long as you're not violating anyone else's rights, you're welcome and free to exercise your rights. So listen to what he said. Matter of fact, I'm going to run it back just a little bit so that you can hear it. Just a little bit.
Of extrajudicial people who are in full possession in your whole life. Okay? I'm trying to hammer home the power of this book to teach you that this is the most valuable book in your whole life. If you know what's in this book, I am telling you, you are in full possession of your American citizenship. If you don't know what's in this book, I am telling you, you're going to be a slave, subject to the whim of extrajudicial people who want to tell you what to do, when to do it, and how to do it, and how high to pack it. Now, my honest philosophy to you is, as a kindness and a Christian to you, I tell you, learn this book, just like you would your...
Stand by, people. I don't know what the hell.
Rights.
There we go.
I love it when these guys tell me I don't have any rights. I said, well, if you believe that, let's go to court.
Let's go to court, goddammit.
At the end of the day, we'll see who owns who. But I'm going to tell you right now, if you violate any of my constitutional rights, I will sue your socks off and I will attach everything you own, bank, business, and home. And I'm telling you, I'm the one your mama warned you about. So damn well better listen. Do not violate my rights, because I will come after you and I will take care of business, and I will do what is necessary and proper, and I will pull every stop out, and I will go dig up every nut, bolt, and screw, and when it's done, you will find out you messed with the wrong American, because this American is not going to back down. Okay? Now,
see the balls on this guy. Of course, that's a white man, and he can have that like that, right? But so can you if you know your rights. Think back, right? I don't know if you saw or seen footage of the Black Panthers when they would talk their shit because they knew the law. Fuck you might learn your rights. This is what he's saying, right? That you can talk just like he can. Now he's a white man, right? And he's able to do that, right? Because he got that white privilege on his side, right? But what sets him apart is he knows what he's talking about in regards to the Constitution. And if you know that shit, you can talk just like him, as long as you can articulate it. Think back to the Black Panthers. I don't know how many of you have seen footage of the Black Panthers talking their shit to police. They knew it, so they could talk their shit, call a cop pig. But they knew the statutes, they knew the laws, they knew what was happening, so they were able to move about, and no one could stop them. I mean, they plotted on them, and eventually they did stop them. But you get what I'm saying, right? On your rights, and you can talk shit just like this guy.
we're going to get into a real special argument. Now, this argument has taken almost 18 and a half years to develop, so I want you to pay attention. Excuse me a second here. This argument is a unique concept that has been honed like a razor to a very meticulous edge so that you can understand what's going on. Obviously, we have established clearly that you have a constitutional right. And obviously, we have established that you are the beneficiary of the contract. And we have established that the Constitution is a contract in writing enforceable in the court of law. And we have established that you have a right to claim specific performance on the contract. And we have established that it's supposed to be interpreted in your favor. So if you got an honest constitutional belief, they have to listen. Now let's take that to the next step. The next step is, can a state arbitrarily and erroneously convert your right into a privilege and issue a license and a fee for it? Now, I don't know if can you see this pretty clearly? This right here. All right. Let's start with here. We're going to start walking down this sheet. Okay. Murdoch versus Pennsylvania, U.S. Supreme Court. Now, when you want to go into the law library and you want to look up something, what you want to do is understand that Supreme Court is Trump. Okay. That's the clearest way I can explain it.
All right. Basically, the Supreme Court, they the HNIC. They determine what's what and what isn't. But they check out what he's talking about. Can the state take your right and convert it to a privilege and license it and charge you for it? And the answer is absolutely not. So he's about to talk about traveling on the roads now. Check this shit out. This is heavy. You don't need a fucking license if you know the law. I mean, people like me who do like ride sharing and use the roads for money, we need licenses. But the rest of you people don't need a license. Check them out.
If you got a Supreme Court case, that trumps a district court, that trumps a court of appeals, that trumps a state court, that trumps everything. So you want to deal with Supreme Court cases as best you can. Murdoch versus Pennsylvania is a unique case. It's recorded at 319 U.S. 105. That's the 319th volume of United States Supreme Court Reports on page 105. So when you go to the law library, go into U.S. Reports, ask the little gal there, or the little guy that's behind the counter, where is the United States Supreme Court Report? They'll tell you right where it is. You grab volume 319, you turn to page 105, and it'll give you the case of Murdoch versus Pennsylvania. Murdoch versus Pennsylvania is a real unique case. And I'm telling you to read the case. The case. You get the case. The judge always likes to see that you're ready. And I'm going to summate basically the case briefly. Basically, it is a religious test case wherein Jehovah's Witnesses in the year of 1943 wanted their right to be able to go and preach among the public, because that is their right to evangelize, okay? In Pennsylvania, they wanted them to have a license to solicit, okay? This is basically the crux of the case. Now, what happened was the Jehovah's Witnesses claimed their First Amendment right of life, liberty, and pursuit of happiness, the right to worship and exercise their religion unencumbered, right? And, of course, that's one of the mainstays that founded this country, was the religious freedom, okay? And basically the points on the case that are established are: a state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involved restrains in advance the constitutional liberties of press and religion and inevitably tends to suppress their existence. All right, let's pull that over there. Everybody see that? Okay. All right, I'll start again. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involved restrains in advance the constitutional liberties of the press and religion and inevitably tends to suppress the exercise thereof. That the ordinance is non-discriminatory and that it applies also to peddlers of wares and merchandise is immaterial. The liberties granted by the First Amendment are and in a preferred position. Since the privilege in question is guaranteed by the federal Constitution and exists independently of the state's authority, the inquiry as to whether the state has given something for which it cannot ask a return is irrelevant. All right? No state may convert a secured liberty into a privilege and issue a license and a fee for it. Now, a lot of people come back to me and say, well, I'm not a Jehovah's Witness, so that case doesn't apply to me. I want you to reach. I want you to understand, we're not talking about whether you're a Jehovah's Witness here. What we're talking about here is, are you an American and do you have rights? What they are talking about here is that these Jehovah's Witness people exercised their rights timely, that they had a right to worship and exercise and worship their God and evangelize as they chose, and that the state came in and arbitrarily converted that right into a privilege and issued a license and a fee for it. That is totally unconstitutional. Now, we took that case as a pioneering case, and we argue that case for all of your constitutional rights. All you need to do is keep in mind that you are an American and you have constitutional rights, number one. Number two, you have to keep in mind what right. Can you pull the right out of the Constitution? If you can pull the right out of the Constitution, and I'll give you an example. How about the right to travel freely and unencumbered, pursuant to Shapiro versus Thompson, and we'll get into that. How about the right to keep and bear arms, right? Does a state have a right to require a license and a fee for the exercise of the right? And if they do, can you ignore the license and the fee? We'll get into that. Now, obviously, in this case, it's clearly established, and this is the premise of this case: no state may convert a secured liberty into a privilege, issue a license and a fee for it, and require you to have that.
Now, check it out. You said the state cannot convert your right into a privilege, license it, and charge you a fee for it. And if they do it, can you ignore it? Abso-fucking-lutely, if you can assert your rights in a timely and effective manner. This is all he's saying. And it's important. Now, understand, people, that these bastards that look like him, and some that look like us, will violate the shit out of you. They'll violate your rights, not give two fucks. But as long as you know them and are willing to fight, right, and assert your rights, like he says, in a timely and effective manner, you will prevail in the end. It's going to take some time. It's going to take some bravery, some courage. It's going to take the stones. You're going to have some stones, some cojones, right? But if you have those things, then you will prevail at the end. Let's go.
Otherwise, you committed a crime. That's totally 100% unconstitutional. I want that to get across real clear. Now let's jump to the next case. By the way, Murdoch is recorded at 319. That's the 319th volume. U.S. Reports, page 105. We'll start the case. All right? Go read the case, though. Make sure you read the case. I don't want anybody to come up and tell me they didn't read the case, because I'm going to get on you. You're not following. That's failure to follow instructions. Okay? Now, We're going to walk down the next step of this case. We took care of Murdoch here. Let's go to Shuttlesworth versus Birmingham, Alabama, which is recorded at volume 373. The same U.S. reports. You go to volume 373, turn to page 262. When we go to Shuttlesworth versus Birmingham, Alabama, this is another unique religious case, okay? In this case, 6 ministers were accused, of inciting to riot and otherwise create a disturbance and disturb the peace, okay? They had a sit-down. This case came down in 1962. And what happened was they said they needed to have a license to have a public gathering, okay? And what happened was it went to the Supreme Court, and the Supreme Court says, no, you don't need to have a license for the exercise of a First Amendment right to freely assemble, okay? Right, basically the gist of the case is the Negro ministers were convicted in Alabama State Court of aiding and abetting in violation of criminal trespass ordinance in Birmingham, Alabama. The only evidence against them was to the effect that they had incited 10 Negro students to engage in a sit-down demonstration at a white lunch counter. Actually, there were 6 ministers, but only 2 got charged, as a protest against the racial segregation. Then they cite other cases. A lot of times you can find other cases in these cases. In Gober versus City of Birmingham, Alabama, this court today holds, on the authority of Peterson versus City of Greenville, that the convictions of those 10 students for criminal trespass were constitutionally invalid. Since those convictions have been set aside, it follows that these petitioners did not incite or aid and abet any crime, and that therefore the convictions of these petitioners must be set aside. Now basically what they were claiming is their constitutional right to freely assemble. The cities was claiming that they had to have a license to put on a demonstration, which they didn't have, and they were charging them with a criminal trespass for not having a valid license to freely assemble and or protest, okay? Now, the gist of this case, I want you to see the significance of this case in view of the case we gave you before that. Murdoch versus Pennsylvania clearly established that no state could convert a secured liberty into a privilege and issue a license and a fee for it. Does everybody got that? Shuttlesworth versus Birmingham, Alabama said that if the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and a fee and engage in the right with impunity. That means they can't punish you. They got to let you go. All right? Does everybody?
Let's be clear. They can and will punish you. But in the end, when you sue them, you will prevail. That's the truth of the matter. Be clear on that. They can punish you. I mean, they can do whatever they want, right? They have the wherewithal. They got guns. They got their perceived color of law on their side. They got everything they need. But when you sue them, and you should, if they violate your rights, what you do is, my bad, you sue the shit out of them. Can you hear me? Can you hear me? Testing 1 2 1 2. Imran Khan, can you hear me? He said sound struck. I have no idea what that means. Anyway, let me know if you can hear me. Type that up. They can punish you. They can and they will, but you can sue them and you will prevail. Check out Mick. What the hell is it? Whoa, bro. Oh, shit. No sound is coming? Let me hear. They can push. They can and they will, but you can sue them and you will prevail. Huh. How about now? Check out Mick. What the hell is it? Oh, bro. No sound is coming? Oh, shit. Sound is coming. Check out Mick. Yeah, my apology. I'm new to this streaming shit. I don't really know how to use it. See, I just bought this mic from the TikTok shop, right? Y'all seen it? Right? There you go. You see it? You see it, right? So I'm just, again, I'm using an antiquated computer. My goddamn phone is the camera. I don't know what the fuck I'm doing, but I'm giving it a shot. In regards to this, what I'm trying to share, brother, if you can hear me okay, what I'm trying to share is the fact that in this country, the U.S., the United Stasi, what we call America, but it is the United States Corporation, there's a constitution here, right? And those are God-given rights that were enumerated, and we have federally protected rights. But the bastards in the courts and in government and in law enforcement and everywhere, these bastards will violate your rights because most Americans don't know their rights. No problem. Elbow. Yeah, I don't know what that means. But anyway, let's get back to the video real quick because it's almost over. I'll holler at you as soon as we're done. Wait, hold on. You can't hear it. We go back to it just a bit.
License and a fee and engage in the right with impunity. That means they can't punish you. They got to let you go. All right? Does everybody see that? It's very important that you understand, first, your Constitution is the supreme law of the land, and you have that right. And that right shall not be infringed, and it's supposed to be enforced in favor of you, the clearly intended and expressly designated beneficiary. It's very important that you understand that no state may convert that right into a privilege and issue a license and a fee for it. And if they do, Shuttlesworth versus Birmingham, Alabama says you can ignore the license and engage in the right with impunity. That means they can't punish you. Now, the next case is very important, and it's very important that you see the argument. Okay? That's United States versus Bishop. That's 412, volume 412, United States Reports. This is page 346. Let me come down here. United States versus Bishop is a very unique case. Basically, what Bishop does is it sets a standard for what constitutes a criminal violation in terms of willful intent. Okay? Willfulness is one of the major elements that is required to be proven. In any criminal element, you have to prove, one, that you're the party, two, that you had a method or an opportunity to do the thing, and third, that you did so with a willful intent. Now, when we get to willful intent, willful is defined as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. Obviously, in the previous two cases, you have decided that you have relied on the United States Constitution, and you have relied on decisions of the United States Supreme Court. So, could you have willfully done any deed or crime? Obviously not. So guess what? This case stipulates that you have a perfect defense to the element of willfulness. All right? Since the burden on the prosecution is to prove that you did willfully and knowingly avoid a known duty or task under the law with a moral certainty, he cannot perform that task, can he? Because it's obviously you have a constitutional immunity to that. The previous case, Shuttlesworth versus Birmingham, Alabama, says they couldn't even punish you. The case before that said you didn't need a license for the exercise of a right. And the case before that said your constitutional right is supreme over any state law. So if they pass a law in violation of your Constitution, the Constitution overwhelms the state law. So the law doesn't even exist in law.
You hearing this shit? I mean, I hope you're getting it because he's dropping jewels. He's giving you case law and the Constitution, telling you that if these bastards get you for a protected right, because you don't, like, for instance, if you get stopped and you got a gun on you and they arrest you for possession of a weapon, it's bullshit. You're exercising your Second Amendment right to keep and bear arms, and there's no license. There's nothing that they could do about that. Nothing. Of course they will arrest you. Of course they will inconvenience you, right? But if you stand on your rights, you stand on that Constitution, you will prevail. And that goes for anything that they've licensed and charges a fee for. anything. Because if the Constitution says we can assemble, then we can assemble. Fuck their licenses and their fees. If the Constitution says that we have the right to express ourselves, like we could freely speak, then we could do that. They can't charge us a fee for that. They can't tell us that we can't assemble, that we can't go into the public and speak, that we got to move. Fuck you. You got to move. Right? We have to really get to learn this. Listen to what this man is saying. This is good shit.
Does everybody see that? Now, since the prosecutor does not have a cause of action for which relief can be granted, Your Honor, may it please the court, counsel is specifically precluded from performing his major task. Therefore, Your Honor, may it please the court, at this time I would motion most graciously for a dismissal with prejudice for failure to state a cause of action for which relief may be granted by this honorable court, and I'd kind of like to collect my costs and fees for having to defend this patently frivolous and spurious complaint, sir. May it please the court. Laughter will usually break out thereafter, at which point the judge will usually turn to the prosecutor and say, "Well, Mr. Prose, what do you think we ought to do about this young fella?" And he'll say, "I'd go for the motion to dismiss, Your Honor," and the judge will turn to him and say, "That's a good answer, because I don't think you're ready for this kid today." And 40 attorneys will break out laughing. Okay, that's actually happened to me, folks. I'm telling you, this argument is a killer argument. It's good for every single constitutional right you've got. All you have to do is fill in the blanks. What constitutional right? Prove that you fill in the blanks. What constitutional right? Prove that you have the constitutional right. Tell them the state doesn't have a right to convert that right into a privilege. Tell them that they can't even punish you if they do. And then claim that the prosecutor can't prove willfulness, so you obviously didn't do no crime, and then flip around and demand for your dismissal, which is your right, and get your costs and fees for having to defend this frivolous case. May it please the court. And I promise you, you will be amazed. 40 attorneys will jump up and say, "Yeah." They'll come up and shake your hand and tell you that's one of the most magnificent arguments they've ever heard. They'll tell you you got something like King Kong for taking on the Bar Association or whatever.
Gotta have the stones. King Kong stones. Because I mean, this is a big giant you fighting here, right? You gotta have stones. You gotta have the testicular fortitude to get up and stand up and fight for your rights. Our leader, our brethren, Malcolm said that if you're not willing to fight, bleed, or die for freedom, well, he said die for freedom. If you're not willing to die for freedom, then you shouldn't even use the word freedom. And I'm adding, fight, bleed, and die for it. You gotta be willing to give it everything you got. And if not, then you know what? Just sit the fuck down and shut the fuck up. If you don't exert or assert or invoke or exercise any right, then exercise the Fifth Amendment and just shut the fuck up. Let them know that I invoke my right to remain silent, and shut the fuck up. Let them do whatever. If they ask you one question after you've invoked your Fifth Amendment right to remain silent, you can sue them under the violation of rights under the color of law. Hold on, let me pull that up so I can tell you exactly what that is. Violation of rights under color of law. Deprivation of rights under color of law. That's Section 242 of Title 18. Yeah, Section 242 of Title 18. You can sue their asses off. You can sue them if they violate your rights, no matter what right it is. But if you don't know your rights, you don't know, just learn this one, the Fifth Amendment. Read it. Invoke your right to remain silent. Like if you get pulled over by a cop, invoke your Fourth and Fifth Amendment rights. Fourth Amendment, you do not consent to illegal searches and seizures, and you invoke your right to remain silent. They can't ask you nothing else. And if they do, record. Make sure you're recording before you do any of this. Record it. If they ask you just one more motherfucking question, you could sue them under Title 18, Section 242. Deprivation of rights under the color of law. Fuck them. Learn something, people. Please. Because I don't know what happened. There was a period in history where black and brown people knew the law. They knew their rights. They were a great and different type of people. And now we just, out here in a covenant with death. We don't give a shit about nothing. Nothing. Like we out here drinking and drugging and fucking and fighting and killing and we don't give a shit about nothing. Yo, if it wasn't for the Hebrew Israelites, right? We wouldn't be shit. Like we would be a bunch of fucking rappers and ball players producing nothing but sweat. Nothing. We have nothing going. I mean, think about it, right? We're the only group of people that entertainers speak for us. What the fuck does LeBron James know about the hood? I mean, yeah, he came from the hood and whatever, but when's the last time he been here? And everything that he putting in the hood, right? Because I hear he doing a lot of shit, but isn't everything he putting in to take out of the hood? What's he actually giving back? And that goes for all of them. Goes for all of them, right? Our fucking leaders are entertainers. We don't have a Malcolm anymore. We don't have a Martin. We don't have a Medgar. Shit. Who do we got? We got who's speaking for us? Nobody. Nobody. And then the ones that do are fucking liberal fruitcakes. They're liberal fruitcakes telling you rock the vote. Who was that? That was Diddy some years ago, right? You see where the hell he at, right? Fucking freak fuck. So people, learn your rights. Learn the law. Get back to being the people that we once were. And unity. Unity is probably what we need more than anything else. Like I said, if it wasn't for the Israelites, if it wasn't for like organizations like Israel United in Christ or Israel School of Universal Practical Knowledge or House of Israel or the Sakari or any one of those brothers, Word is Born, we wouldn't be shit. We wouldn't be nothing. We would just be a bunch of fucking niggas in the street selling drugs and killing each other, fucking each other's baby mamas and producing children and not taking care of them. We wouldn't be shit. So learn this shit. And I know that's a white man teaching you, but who better? Who better than a motherfucker who understands that he's the absolute authority in this shit? So let's finish it because this is the last part.
Now, I'm telling you these things
The last part of this video. This is the third part.
personally happened to me. I can relate the exact cases. That goes for practicing law without a license. Obviously, you got a right to work. You got a right to contract your right to work as you see fit, not as some arbitrary and capricious bar association sees fit. Right? Doesn't that make sense to you? You don't want to belong to the union. That's your right. This is a right to work state, right? The bottom line is this: they cannot compel you to have a license or pay a fee for the exercise of your right. And if they do, you can ignore the license and a fee and engage in the right with impunity. That means they can't punish you. And since you got a perfect defense to the element of willfulness, they cannot punish you. They have to dismiss. They do not have a cause of action. Now, this argument I'm telling you has taken us over 18 years to develop in courts and in law libraries over the years, and just kind of compiling and arguing cases and doing this. This argument is a killer argument. Have they ever won against us on this argument? Nor could they in the United States of America as long as the Constitution stands. I'm asking that you pay attention to this argument and start utilizing it. We'll show you some of the techniques later in the second half, all right? Now, the word willfully has the same meaning, all right? In controlling the voluntary, intentional violation of a known legal duty. And the distinction between the statute is found in the additional misconduct that is essential to the violation of the felony provision. If they can't prove willfulness, they can't prove nada. Okay? Has everybody got that? Now, let's go to the next one. Now that you've won and your rights have been violated, the next thing they will claim, well, we acted in good faith, or, well, we acted in good faith. We had good faith reliance that you broke the law. Okay? And that means you can't sue us. That's a lie. You see, since these two cases, Owen versus City of Independence, which is recorded at 100 volume, and you want to look at Supreme Court reports. Now, that's a different reporter. Supreme Court reports will actually say on the back of the reporter, Supreme Court reports. It won't say U.S., it'll say Supreme Court reports. So that's a different volume. It's a newer reporter. So you want the 100th volume, and you want to look up Supreme Court reports, and you want to turn to page 1398. There is also a counterpart case to this Owen case, which is Maine versus Thibodeau. I'll give you the site for those. Okay, I gave you Owen versus City of Independence, so I'll give you Maine versus Thibodeau. Maine versus Thibodeau is recorded at 100 Supreme Court. That's 100th volume. Supreme Court Reports, page 2502. Now, basically, the summation of what these basic arguments say: where plain language of a statute supported by consistent judicial interpretation is strong, it is not necessary to look beyond the words of the statute, right? Now, these are both civil rights cases. The right of action created by statute relating to deprivation under color of law, of state law, of a right secured by the Constitution and the laws of the United States encompasses claims which are based solely on statutory violations of federal law and apply to the claim that claimants had been deprived of their rights in some capacity to which they were entitled. Now, whenever this happens, folks, you must understand something. And that goes for both Maine versus Thibodeau and Owen versus City of Independence. And I'll tell you the brief synopsis on both these cases. Owen was a police chief in a town of Independence, Missouri. And he got in a gripe with the city council, and they indiscriminately fired him without just cause. Owen turned around and sued. They claimed that they acted in good faith. The Supreme Court said, "Sir, you are deemed to be officers of the law. You are to advise us to the law. You can hardly claim that you acted in good faith for a willful deprivation of the law, and you certainly can't claim ignorance of the law, because a citizen out here on the street can't claim ignorance of the law, and it makes the law look stupid if an officer of the court or some officer of government doesn't know the law, and then they go ahead and abuse somebody's constitutional rights." So in matters of constitutional rights, both these cases uphold one point. And the point they uphold is that whenever they violate your constitutional rights, they do so at their own peril. And it even says that in Title 18 United States Code Section 241 and 242. It says that upon conviction you are subject to a $10,000 fine, 10 years in jail, or both, and if death results, life in prison. They're telling you, don't violate somebody's rights. Please, don't do that. Title 42 United States Code Sections 1983, 1985, and 1986 clearly establish your right to sue anybody that does that. Now, they're going to claim you can't sue them because they have judicial immunity. Well, guess what? These two cases remove judicial immunity. There is no judicial immunity.
There is no judicial immunity. You can sue their ass if they violate your rights. Go back and watch this. I mean, like I said, nobody's watching right now except a few people who may watch or may not. But this is gold. This is solid information. This is teaching you how to defend yourself and how to sue agents of government, go after their bonds. He just told you all the different sections and titles, right, on how to do it. They're going to tell you that you can't do it. You can. You absolutely can do it. Fuck them. Sue them.
For violating somebody's constitutional rights. Judge, you are deemed to know the law and sworn to uphold it. You can hardly claim that you acted in good faith for willful deprivation of the law, and you certainly can't plead ignorance of the law, for that would make the law look stupid for a knowledgeable judge to claim ignorance of the law when a citizen on the street can't claim ignorance of the law. Therefore, there is no judicial immunity. I want to get that across. I don't know how many attorneys come up to me all the time telling me, well, they're immune because they acted in good faith. They're just not reading their court. They're not reading their court reports, because if they had reading their court reports, they would have known this case has been on the books since 1982. Both these cases came down in 1982. So I want you to pay attention to these cases. When somebody tells you they can violate your rights with impunity, you just kind of smile and say, make my day. Okay? Now, the next case we're going to talk about is Rights versus United States.
Make my day. So when these bastards violate you, like I said, just be cool. Learn the shit. You can't do anything about anything till you learn it, right? Knowledge is power. Platinum and ice, that's for bitches. Learn this shit so that you can be empowered to not only assert your rights, but defend the rights of others. And you really can't. They got to defend and assert their own rights. But by doing so, right, you empower the rest of the people. So just learn this shit. I can't stress that enough.
We mentioned it previously earlier. Briars is recorded at 273, volume 273, U.S. Reports, page 28. Okay? Now, Briars versus United States is a unique case. It's a search and seizure case, but basically it sets constitutional standards which we had talked about in the AM jurisprudence sections. Okay? I especially want to pay attention to note number 3 here. Constitutional provisions for the security of a person and property are to be liberally construed, and it is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachment therein. All right? when a federal officer participates officially with a state official in a search, so that in substance and effect it is their joint operation. The legality of the search and the use and evidence of the things seized is to be tested in federal prosecutions, as it would be if the undertaking were exclusively the federal agent, all right? The reality here is what they are setting is the standards must be liberally construed in favor of the citizen. It's the duty of the court to make sure that happens. So now you have a right to be wrong. You have a right to enter your viable defenses that you honestly think. No state can convert that right into a privilege and issue a license and a fee. If they do, you can ignore the license and the fee. They must prove the burden of proof of willfulness, which they cannot do. If they do violate your rights, you do have a right to sue them in Owens v. City of Independence and Maine v. Thibodeau. They have to give every consideration to you, all right? And that's the way it is. 1900 yesterday, all right? The next case we want to talk about is Boyd. Boyd versus United States is recorded at, it's recorded at 116, volume 116, United States Reports, page 616. So everybody got that? Can you see? Bear with us, folks. We're really trying to jam here for you. Boyd versus United States, 116 U.S., page 616. The court is to protect against encroachment of constitutionality or secured liberty. All right? Now, it is equivalent to a compulsory production of papers to make the non-production of them a confession of the allegations, which is pretended they will prove. And a lot of times that happens in federal cases. They'll claim something, they won't prove it. This happened to me, believe me. And then the fact that they've claimed it makes it true. All right? Now this, excuse me. And then, of course, you have to prove a negative, which is impossible. All right? Now, the seizure or compulsory production of a man's private papers to be used in evidence against him is equivalent to compelling him to be a witness against himself in violation of the Fifth Amendment, and in a prosecution for a crime, penalty, or forfeiture is equally within the prohibition of the Fifth Amendment. See that? Now, the bottom line here is Boyd protects against encroachment of constitutionally secured liberties. It's arguing the Fifth Amendment here, but it's basically arguing against encroachment, all right?
All right. That's the end of that part, right? I'll put the other ones up soon. But to recap, you have rights. They can't violate your rights legally. They can do it, but legally they're not supposed to. They can't get that. You're supposed to be able to sue them, and you can under Title, what was it, 23? Under Title, hold on, I'm looking at it. Title 18, Section 242 of Title 18, right? And that's just one. There are so many. He named all of them, or at least most of them. To recap, you have rights. Exercise those rights. Learn those rights, then exercise them. Assert them in a timely and effective manner. Know what you're doing, and understand that these bastards will violate you, but you can sue them, and you will prevail in the end. So, all that to say this. Learn your rights, and we'll get back to it tomorrow. You heard? Or another day. I don't know exactly when. But I'll holler. You all have a great day. Shalom, people. Imran Khan, assalamu alaikum.